Well, President Cyril Ramaphosa has filed papers to urgently interdict his predecessor, former President Jacob Zuma's private prosecution against him. On the eve of the ANC's 55th National Elective Conference, Zuma issued what the president called a defective summons against Ramaphosa. This concerning the disclosure of the former president's medical records by state prosecutor Advocate Billy Downer and News 24 journalist Karyn Maughan. That whole legal saga then prompting another legal saga now with the two presidents, or president and former president, the two ANC leaders butting heads. I'm joined now by Mpumelelo Zikalala, a legal analyst on the line to us, or on the screen to us, I should say, all the way from Durban. Mpumelelo, we've just had a look at this urgent interdict set of papers filed yesterday by President Cyril Ramaphosa. He's arguing that any steps taken in terms of a nollie prosecute, a private prosecution certificate obtained by Zuma in November of this year, be blocked, that Ramaphosa be excused from appearing in court on the 19th of January or any other date that might come up, and that Zuma pay the costs. Some of your initial thoughts on this latest legal step in what is becoming a legal political soap opera?
Definitely, but I think we must go back to the basics and look at the basics of the rules that apply to urgent interdict. If you're going to bring an urgent application, you're basically saying to the court, I want you to jump the queue, I want you to overlook and condone any other non-compliance with any of the rules which are applicable to us, which are mainly time-based. So in this case, the president is saying, I have a certain right that I need to protect. I'm going to suffer irreparable harm, and the balance of probabilities, I'm probably going to be successful, and there's no other alternative that can be there in order for me to solve this particular matter. That's where I may differ a bit with the application of the president, because there are various instances in which what I've stated above does not apply. Firstly, there are other defenses that are there. If you look at Section 106 of the Criminal Procedure Act, it speaks directly to the title of no title to prosecute, which what the president is attacking pertaining to this particular matter. Secondly, the alternative means which are there to resolve this particular matter is to go to court, file your particular defense, and be able to solve the matter once and for all, where a court of law is going to pronounce it. So, where one, maybe we haven't looked at the papers, I must admit, but one would need to see what is the irreparable harm that the president is referring to. Is it something which is really irreparable, or it is something which is more brand related rather than certain things of instant or things that are of merit? For me, the court is where this particular dispute should be resolved. That's why we have court of laws at the end of the day. And there's a specific section that deals with this particular dispute, which is Section 106 of the Criminal Procedure Act. So on the basis of bringing this on an urgent application, I don't think it was necessary. What needed to happen, though, was to write to the NPA and say to the NPA, in terms of the Criminal Procedure Act again, Section 8 up until 18, deals with your powers to issue this type of certificates. I have reason to believe that the certificate that you have issued, NPA, is going to tarnish my image, and it has not been properly issued, or it is ambiguous in the manner in which you have written it. Can you please resolve this particular dispute, withdraw it, and then issue another fresh one which is suspect specific, and then allow me to continue with my business as I would. Unless if you are of the view that I should be privately prosecuted, only then will I form part and parcel of these particular disputes which are taking place. So I think this matter, the president, yes, he can go to court on an urgent basis, but I think the real people that should answer and be able to solve this entire mess of this dispute, which is the NPA.
Just to come back to that, Mpumelelo, I hear you. Talk to us about the delicacies of a head of state writing to the prosecuting authority in a matter involving him and litigation and addressing this question of the nollie prosecute certificate. I mean, in the interdict papers we've now seen, he does refer to that certificate and highlight the issue of interpretation of whether or not it actually relates to him. We did see some days ago an NPA statement noting that the nollie prosecute does not refer to Ramaphosa, but there are quite delicate lines here and important lines distinguishing between different arms of government. How could he possibly write to the NPA without being seen to be abusing his powers?
Those different lines of authorities or government that are there are precisely to ensure that they are able to think independently and be able to act independently. So the president would be writing and saying to the NPA, I'm a litigant in this matter. I'm not giving you a direction as to how you should prosecute or handle this particular matter. All that I'm looking for, first, is for clarity. Have you issued a particular certificate? I'm of the opinion that it is ambiguous. It is not specific, because you haven't really stated the name of the suspect. It should be there. If you look at the one which was issued against Billy Down, which is very specific, it says the suspect is Mr. So-and-so, and the respondent or the person who's going to prosecute is a former president. So one would have expected the same to apply when a certificate is issued against the president, because at the end of the day, the NPA has got to prove that it has looked at the individual or tailor-made merits of the matter against the president, and have decided that despite the evidence being there, they're not going to prosecute because they think, or they're of the opinion that they won't come back with the conviction, or the evidence that is there cannot come back with the verdict saying that the person is guilty beyond reasonable doubt. So on that basis, that particular certificate must be specific. If you are going to issue a blanket certificate rather than the one that has been issued now, you are basically, as the NPA, delegating your authority and your duties to prosecute to somebody else, which is something that should not be done. And you are giving them unfettered powers to simply decide, this is the person that you are going to prosecute, these are the other individuals that you are not going to prosecute. It does not work that way. So if the NPA has made a blunder, and if you can see that the NPA is the one that can be able to solve this particular matter, start with the NPA first, because you want to go to court as an innocent litigant and say to the court, I've tried all means. I've spoken to the NPA. I respect them as a separate legal entity which is independent from me, not controlled by me. To see that, I would have easily issued an instruction if I was going against the law of contravening the separation of powers, and say to them, don't prosecute me. But I complied with it, and I was pleading with them and saying to them, can you please fix the mistake that you have done so that I can be able to continue with my life? They've ignored me. And the other integral part of this particular application, because without the certificate being issued, there's no litigation which is going to take place. So if I can feel that something wrong has taken place, and that's where I might start before I continue. But the second basis of it then says, if you look at the Criminal Procedure Act, Section 106 is very clear. One of the defenses in which one can raise even before a matter starts, or even before we look at the merits of the matter, is to say that there's no charge to prosecute, which is what the president is contending or stating in his paper. So on that basis, that's where his defense is going to be laid. That's where his defense is going to be ventilated, not in an urgent application, because that would mean there are alternative dispute resolution processes that are there, but you just want to jump the queue for reasons which are only known to you, or the reasons that you can be able to substantiate, especially if you can be able to prove that you are going to suffer irreparable harm.
Yeah. So Mpumelelo, what I hear you saying is really a kind of query or a doubt around this issue of an urgent interdict. You're talking with your lawyer's hat on, but looking to this from a more political perspective, if we check out the dates involved, it maybe starts to make a little bit more sense. The former president had given this date of the 19th of January for President Cyril Ramaphosa to appear in court in this private prosecution with a looming sentence in jail of 15 years. And now the president's saying that he wants the same court to hear his urgent interdict on the 10th. He's also given some dates for a notice of an intention to oppose. He wants that from Zuma, in fact, by tomorrow. And then an answering affidavit, if warranted or if needed, if relevant, by the 3rd of January. That's the day or 2 days before the ANC's elective conference is meant to wind up. I don't want to fill your legal brain with its statutes and case law with too many political points here. But as you say, this issue of urgency, you've got some questions around it. Would that be the approach for the former president to take in any opposition if he were to file one?
Definitely. He's going to say the matter is not urgent, just must follow the normal court road. If you don't want us to continue with the other one, there's no interdict which is going to be issued. If there's no interdict issued, it means on the 19th, the current president, Mr. Ramaphosa, will have to appear in court unless there is a discussion that is taking place between the two. The alternative could have been that, just to sit down and say, because there are legal wranglings and legal disputes which are currently taking place, can we have a sort of an agreement to say, don't appear in court up until those particular issues have been ventilated. But taking into account the stance and the communication that have been taking place between the two parties, I do not see them arriving at any consensus in this particular matter. So we may have to see an urgent application sitting first, and if that urgent application is successful on that particular date, then on the 19th, the president will not appear in court. If they are not successful, then on the 19th, the president will appear in court, unless the parties have sat down together and resolved this particular matter, or unless the NPA has come back and saying that we are withdrawing this particular certificate, you are going to issue another one, and by the withdrawal of the certificate, you are basically taking the powers of prosecution and the powers that would have been required by the 19th of January by the former president. I again foresee a fierce amount of contestation that will take place, and probably another implication that will be brought in by the former president. But at the end of the day, it would have been able to solve the issue and the misunderstanding which is currently taking place.
Doesn't sound like alternative dispute resolution is going to be a viable option in this one. Mpumelelo Zikalala from Durban on the line to us, or the screen to us, as I said. Legal analyst, thank you so much for your time on that breaking news story. President Cyril Ramaphosa has filed an urgent interdict against the private prosecution brought against him by former President Jacob Zuma. With that, Ramaphosa says defective summons served on his private residence just the day of the beginning of that ANC elective conference.